case you're wondering, it's 33 days. Not that I'm counting. I appreciate the chance to be here today to speak to you. I think this is an important opportunity for me, so I want to talk to you about several things. But first, I think if you've seen the ads, you know something about me, that my parents ran the Masonic Home for Children in Meridian. And I really did grow up with 60 brothers and sisters. But they also taught me two big lessons. One was that we're all different, but we have to play by the same rules. And the second was that we have a responsibility for service. And I believe my talents are in the role as an appellate judge. And I've chosen to dedicate most of my career, in fact, the rest of my career, to serving Mississippians as an appellate judge. I believe it's important that we restore confidence in our courts, and that we do that by making decisions based on the rule of law. My opponent and I have a number of opinions, by my count over 10,000. You'll see that through these opinions, I believe that my opponent in the last 8 years has aggressively attempted to change criminal laws in the state and expand civil liability. I don't think judges should legislate from the bench. I think the future of our courts needs someone who will follow the law, who will make our courts accountable and transparent and bring innovation and reform to the judicial system. And that's going to take a lot of work. And that's really why I'm asking for the job, because I have that calling and I have the proven experience. And I believe 5 things that we need: accountability, integrity, transparency, consistency, and innovation. That's the future of our courts. Let's look at some of the recent headlines. Just this week, there's a report about a federal judge that had 2 cases reassigned from him. The Fifth Circuit took that action because they decided the motions had languished too long. Court statistics revealed that the judge had over 100 outstanding motions. The next closest was 9. The other judges knew the report was coming, and they were accountable, and they got their work done. That's accountability, and there's no reason we can't have accountability in our courts. You know, we don't have these statistical reports. We should. The information is easily available on the Mississippi Electronic Court System, and the Supreme Court can use the Administrative Office of Courts, the AOC, to provide that information. Their mission is to collect statistics from courts, improve the administration of justice, and require filing of such reports. This information should be published to the members of the press and the public, because that's accountability, and accountability is the future of our courts. Next, let's talk about integrity, specifically in our criminal justice system. Justice Kitchens is right. We need work in our criminal justice system. The difference between us is I don't think it simply comes from opinions written by the Supreme Court justices. I believe it's going to take work through commissions and other work that is spearheaded by the Supreme Court. There's a recent article about lengthy jail detentions and delays in trials and appeals. Lee Vester Brown, he was convicted of capital murder of his son in 2006. The case stayed at the trial court until 2012. 6 years it languished there. 2 years later, at the Supreme Court, they reversed the case and found the trial judge had improperly denied his request for expert funds. My opponent wrote a specially concurring opinion that I think is important. He said, all of us who bear responsibility for the reliable and timely functioning of our state's criminal justice system should be ashamed of the systemic failure which occurred in the case of Lee Vester Brown. So much so that we rededicate ourselves to the resolute determination that such thing would never happen again. Ashamed is a harsh word. Rededicate ourselves is a promise. Never happen again is also a promise. And never. And yet 18 months later, this past May, Jerry Mitchell writes another article in the Clarion Ledger about Stephen Jesse Harris. Mr. Harris has been held in the Clay County Jail since his October 8, 2005 arrest, charged with murder. He's been in jail for over 3,700 days, and Jerry said that was a state or national record. But 2 years earlier, my opponent had said that we were embarrassed by this or ashamed. and that it should never happen again, and that we would rededicate ourselves to make sure that it didn't happen again. We should, but it did. We've got to decide what to do about our state's reliable and timely functioning of our criminal justice system. I agree, we need more than words, we need action. Because this is integrity in our criminal justice system, and integrity is the future of our courts. I've also talked about transparency. We elect judges in Mississippi, and we want our judges to be held to a high standard. The election of judges is really important to lawyers, and some lawyers have a special interest in judicial elections. We've seen lawyers who make millions, even $1 billion on one judge's decision. Yet we've had no significant reform since the scandals dealing with Dickie Scruggs and Paul Minor, two of our richest trial attorneys and several former judges who went to jail. Those scandals were about loans and special access to judges. In 2008, I applaud my opponent because he complained about special interest and promised that he would promote a discussion about how we finance campaigns in Mississippi. He too wanted to reform judicial finance reform. He won, but I haven't seen the reform that we need. Mississippi's past should make us the leader in judicial ethics and integrity. At the Neshoba County Fair, I outlined what my view was on reform for judicial finances. Frequent and full disclosure, monthly reporting, real-time reporting. All contributions should be disclosed. No contributions after Election Day. That's the worst abuse that there is, when someone can win the job and then say, come to the throne and lay down your treasures before me. In 2008, my opponent raised over half of his contributions after the last pre-election report. We need to prohibit judicial campaign loans, because no one takes out a loan unless they have a plan to pay it back. It's simply a way to hide the contributions and possibly mislead the public. We need tighter restrictions and rules on lawyer contributions. Do you know that there's not a rule that requires a lawyer a judge to disqualify based on a lawyer contribution? That discourages contributions by ethical and honest lawyers because they're worried about the perception of impartiality and gives advantage to those who are not. Either a major donor requires automatic disqualification or it does not. We need to set the amount and decide. We also need to audit and enforce our rules. Bank and credit card statements should be filed, and there should be officials that are authorized to audit those reports and make sure that there are no violations. As a former CPA, I recognize the power of disclosure, that transparency is what protects us against corruption. And I know that transparency is the future of our courts. I also have a passion in another area, and that's consistency. I'm concerned about our rules of court. The Mississippi Supreme Court sets the rules of court and the procedures that we follow. When I started, we had 7 sets of rules. Today we have 21. Many of those are outdated, they're confusing, they're routinely ignored, and even laughed at. We've got too many rules, and this is an access to justice issue in my mind. It discourages lawyers from offering their time and services to help the poor. I think we've got to get rid of those tricks and the gamesmanship, and we've got to have rules that make sense. Also, I think all rules should be public. I don't know if you're aware of this or not, but the Supreme Court has a set of rules that you've never seen, and I haven't either. But they deal with the procedure the Supreme Court is to follow in how they decide cases. I think those rules should be published. I've asked for those rules, and I've been denied my request for those rules. Those rules should be disclosed. All rules should be disclosed, and they should be applied consistently. And consistency is the future of our courts. Finally, innovation. I agree with my opponent. The most challenging issue we face in the next years, certainly the next 8 years, is the criminal justice system. We need to make sure it works. My vision is that the Supreme Court will be the innovator, that only the Supreme Court can get lawyers, law enforcement, prosecutors, defense attorneys, the Department of Corrections, mental health, the State Crime Lab, trial judges and victim advocates together. We have limited resources, and we must use the data and technology that we have to fight crime and incarcerate or rehabilitate offenders. There's no reason in 2016 that we can't start with communication. We must have real-time information to law enforcement officers, 24/7. We must simplify the filing of police reports and the retention of evidence. We need to facilitate quick decisions on bail. We need to enable and track communications between law enforcement and prosecutors. And we need to provide timely information to defense attorneys. But most of all, we need to monitor and supervise prisoners who are both in and out of jail. Data and information is going to be the future of the criminal justice reforms that we need. It requires innovation, and I'm willing to work with others to make sure that there are reforms to our laws and our institutions to make sure the public is safe from predators, and those we punish, that we punish appropriately, that we use taxpayer dollars wisely, and that we protect the rights of the accused. There's a lot of work, and we need a new generation of judges who will lead this effort to the 21st century. But innovation is the future of the court, and that's my vision for the future and for the next 8 years. But let me stop and tell you about why I think you should vote for me. I don't know that there's been a Supreme Court race that has had two candidates with as much appellate judicial experience as my opponent and I. But I'm not running for the judge or prosecutor, and I'm not running for the job of a criminal defense attorney. I'm not running for the job of a trial judge. I'm running for the job as your appellate judge. And the most important job the Supreme Court does every day is to decide cases. And I don't get to pick the cases that I get to decide. The Supreme Court decides which cases they're going to deflect to the Court of Appeals, and we handle those cases and handle them well, I believe. I hope you realize that the work of the Court of Appeals is equally important as that of the Supreme Court. I'm in my 14th year at the Court of Appeals. You may not believe it, but on the Supreme Court, only the Chief Justice and one other justice has served longer as an appellate judge than I have. On my court, I'm the third oldest judge on my court, and I'm the third longest serving. But since 2002, I've been reelected, twice unopposed. I was in a contested race at that time. Chief Justice Waller proudly refers to the Court of Appeals as the workhorse court. I don't know how I feel about being called a horse, but I think he's exactly right. We handle 80% of the appeals. We do so promptly. We issue clear and understandable opinions. We work hard to achieve unity in our decisions to make sure the bench and bar understands it. And we are routinely praised by the Chief Justice, other Supreme Court justices, and the bench and bar. I don't want to go into too much comparison, but I have served now almost twice as long as my opponent. I've decided over 4 times the number of cases. I've written over 900 majority opinions and less than 300 separate or dissenting opinions. My opponent, with a fourth of the caseload, has written over 600 dissenting and especially concurring opinion. In almost a fourth of his cases, he writes separately from the rest of the court. He disagrees with his colleagues a lot. And I think the Supreme Court needs a consensus builder. They need unified opinions that clearly state the law. And let me talk about the cases that we handle. I don't just write opinions. And quite frankly, I am somewhat offended when it's said that all I do is write opinions. Because I read every one of those carefully and look behind the opinions at the trials as I'm supposed to do as an appellate judge. I look and use my abilities to review the case based on the appropriate standard of review and make sure that the law has been followed. I work very hard, as do my colleagues and those who have preceded me on the Court of Appeals. And the Court of Appeals is a success story in Mississippi. You see, before the Court of Appeals came along, you had about a 3 to 5 year wait to decide an appeal. With the Court of Appeals, you get your decision very promptly, and you get a clear written opinion in all cases. But let's talk about the cases I've handled. To give you an example of a few, I've handled almost 100 capital murder cases. Murder cases, manslaughter, armed robbery, aggravated assault, burglary, sexual battery, rape, sale of drugs. All of these cases are what go into that 8,000 cases that we've decided. We've not just written opinions, we've decided the cases and provided the law that is followed throughout Mississippi. We deal with real people and real lives and real cases, and we affect their lives. I understand that there are times that I may be the only person that stands between an innocent person and a lengthy prison sentence. But I also understand that I may be the only person that stands between a victim and justice. How we decide these cases is our record. And I do hope that this election is decided based on our record, because there are 10,000 decisions of actual, real cases that will tell you about our judicial philosophy and what you need to expect from your Supreme Court justice over the next 8 years. This is the longest term in state government, and the person you elect 33 days from now will serve you through 2024. But let me tell you some statistics that I don't know if you're aware of. In criminal cases over the last 7.5 years, my opponent has voted to reverse more than 50% of the criminal cases. And last year, the number was around 65%, when the rest of the Supreme Court was affirming the cases at a rate of around 78%. When you go to vote, and ladies and gentlemen of the media, when you report on this campaign, I hope the discussion is about our record and consider where each of us will lead the court in the future. Because I do believe this race is between two honorable and well-qualified men who care about the future of our state, who want to serve the state, but have a different judicial philosophy. And the person that's elected should be based on what the citizens want that judicial philosophy to be. I'm Kenny Griifis, and I'll ask each of you for your vote on November the 8th. Thank you very much.